Hello and welcome to Devil's Advocate. Is the Prime Minister becoming embroiled in the Colgate controversy? That's the key issue I shall discuss today with the Minister of Information and Broadcasting, Manish Tewari. Minister, let me start with the issues raised by the former Coal Secretary PC Parekh. He says that if Mr. Birla and he are to be embroiled in a controversy and a conspiracy, then surely Dasari Narayan Rao and the Prime Minister must be part of the same conspiracy, because without them signing on the file, no coal block could have been allocated.
Karan, I think we need to take a broader view of what the issues involved are. The first issue is allocation qua auction, and that was settled in the 2G matter, where allocation got you 14,922 crores and auction got you 7,671 crores. Now is the process coming to the process of allocating coal mines from 1993 to 2009. 22 ministers, including 2 former prime ministers, 1 deputy prime minister, and the current prime minister have held the coal portfolio.
I don't deny any of that.
And the entire process of allocation has been the same.
I don't deny any of that. I'm talking not about the entire process. I'm talking about one specific allocation where Mr. Parekh and Mr. Birla have been accused of a conspiracy. And I put it to you, as Mr. Parekh says, that if they are guilty of conspiracy, then surely Dasari Narayan Rao and the Prime Minister must be part of that conspiracy, because without those 2 ministers signing off on the file, the allocation couldn't have happened.
Without going into the merits of the matter, since it's sub judice and is under investigation, let me very respectfully point out there's a difference between an administrative head and the political head of a ministry. And the Prime Minister was only holding the portfolio in interim. So therefore, by the time a file comes to the Prime Minister, it's being processed by the coal bureaucracy and the bureaucracy within the PMO. So to expect Prime Minister to scrutinize every file and then sign off on it, and that being used by the former coal secretary to say that the Prime Minister is equally complicit, I think is a bit of a stretch.
Well, by the way, you've overlooked several things. First of all, the Prime Minister was a substantive coal minister at the time. He wasn't an interim coal minister. Number 2, the Prime Minister, when he signs on a file, is exercising his judgment. If he signs without exercising his judgment, that is negligence, if not also irresponsibility. Therefore, if he signed on a file allocating a coal block to a particular entity, he's taking responsibility for what he's done. He then can't turn around and say, I may have signed, but the responsibility is the coal secretary's. That is not just irresponsible, that is trying to hand over responsibility to someone else.
Allow me to answer both those questions straight off. First of all, the Prime Minister was holding the portfolio in interim twice when Shibu Soren resigned, but as the coal minister.
During this period.
So therefore, obviously, because between 2004 and 2009, Shibu Soren resigned, if not thrice, at least twice. Number 2, as I was earlier pointing out, you see, the ministers deal with issues of policy, substantive issues of policy. Administrative matters are dealt by the secretaries who are administrative heads of the ministry. There is nobody trying to escape responsibility, Karan, but I'm trying to make the distinction that by the time a file comes to the Prime Minister, who's the interim head of a particular ministry, it's gone through the entire coal bureaucracy, the entire bureaucracy of the Prime Minister's office, and for the Prime Minister then to disagree with that recommendation, I think is a bit of a stretch, for the lack of a better word.
The chronology you're sketching out is wrong. The file didn't go through the system to the Prime Minister. This matter began with the Prime Minister. And let me give you the facts. Before Mr. Birla met Mr. Parekh, he met the Prime Minister. Second, the representation and documents he gave the Prime Minister were sent by the Prime Minister's office to Mr. Parekh for examination and investigation. It was only at that stage, afterwards, that Mr. Parekh met Mr. Birla. So if by that chronology Mr. Parekh is guilty of a conspiracy, surely the Prime Minister must be, because it began and initiated with him.
May I put it to you, Karan, is it a crime for the Prime Minister to be meeting with an industrialist? Is it a crime in a democracy for a Prime Minister to be receiving a representation from an industrialist? And so therefore, is it a crime for the Prime Minister to pass it on to the bureaucracy to process it? So therefore, this particular statement that if I am complicit, and I'm not even going into the merits of it, whether he's complicit or not, so therefore the Prime Minister should be complicit, I think is completely out of order.
Well, no, I was actually countering the point that you made, that the process began at a lower level, went through the Coal Secretary to the PM, and I'm pointing out to you that this time round, the process began with the PM. Mr. Birla met the PM first, he gave his representation to the PM first, the PM's office sent that representation to Mr. Parekh, only then did Mr. Parekh meet Mr. Birla. So, if chronology is important, the chronology is the wrong one. It doesn't suit your purpose.
99% of the times, Karan, representations are made to the minister. The minister marks it to the bureaucracy, and that's when the process starts. The process does not commence with you coming and giving me a representation. Process starts when I refer it for processing. So therefore, the chronology of processing is because I don't take a decision on your representation. I take a decision on the process which has been initiated by the ministry.
If the minister, the Prime Minister in this case as Coal Minister, takes a decision on the process, then I accept that the recommendation he received from Mr. Parekh was to set aside the original screening committee decision and split the coal block between Neyveli Lignite and Hindalco. But it was only a recommendation. That recommendation could not have come into effect until Dasari Narayan Rao as Minister of State and the Prime Minister as Coal Minister signed on it. And as I put it to you at the very beginning, those ministers have to exercise their judgment. Not only did they not, they actually endorsed the recommendation they got, so they take responsibility for it. Now, if that ends up being a conspiracy, they are part of the conspiracy.
Again, let me again point you to the whole allocation process. There was an interministerial committee which was put in place in 1993. The interministerial committee screens all the applications, arrives at recommendations, and then those recommendations are sent to the political executive.
It's only a recommendation.
That's I completely agree with you, but invariably, the political executive does not gerrymander with the recommendations, and especially so the Prime Minister, who as head of government is not really looking after one portfolio, but is looking at the entire pantheon of the government paradigm.
Mr. Tewari, you've been a minister long enough to know that there are many instances, not just in the coal ministry, but in every ministry in government, when ministers receive recommendations from their secretaries and turn them down or set them aside, right? The Prime Minister in this instance didn't. And the reason he didn't is because he agreed with the recommendation. And when he agreed with the recommendation, then he becomes part of the so-called alleged conspiracy, if there is one. And that's...
First of all, I think we need to hair split. And the hair splitting is that what you rightly pointed out, A, whether there's a conspiracy, and hypothetically presuming, since the CBI has filed an FIR.
If there is a conspiracy, the PM is part of it.
Presuming that there's a conspiracy, since the CBI has filed an FIR, to extrapolate and stretch it just because the Prime Minister has signed off. So therefore the Prime Minister is complicit. I respectfully would disagree with you.
The point I'm making, and this is in fact the point Mr. Parekh made as well, that arguably the responsibility of the Prime Minister is even greater than that of the Coal Secretary, because the Prime Minister could have turned down the Coal Secretary's recommendation. He didn't. He in fact chose to endorse it. As I say to you, if he endorsed it after exercising his judgment, then he did so knowingly and willingly, and therefore he's part of the conspiracy. And forgive me, let me finish. And if he did it without exercising his judgment, then he was negligent and irresponsible.
As I was pointing out to you, the convention is that when something has been deliberated upon by an interministerial committee and a recommendation is made by the secretary of the department, invariably 99% of the cases it is accepted. If at all there's a disagreement, then you have to pass a reasoned order as to why are you disagreeing with the recommendations of the interministerial committee. So therefore, for Mr. Parekh to take this stand now, because if I made the recommendation and I'm being made a part of the conspiracy, so should the Prime Minister, I think is completely out of order. There is no jurisprudence which really substantiates this kind of a reasoning or this kind of an argument.
There are facts that substantiate the point Mr. Parekh is making, and they are there in the paper, The Hindu, on Friday. First of all, you keep saying when an interministerial committee sends a recommendation, it's quite acceptable for the Prime Minister to sign on the dotted line without questioning it. Actually, it was a recommendation from the Coal Secretary to change the original decision by an interministerial committee. An interministerial committee had not met a second time. So when he actually got the recommendation, it was simply from Mr. Parekh himself. There was no interministerial committee. And let me finish. And therefore the argument that the PM can sign off an interministerial committee decision without applying his mind or without questioning it doesn't hold in this case.
So
because this didn't come from an interministerial committee.
Therefore, Karan, that validates my argument even further.
It knocks it aside.
No, it doesn't. It doesn't knock it out for the simple reason that when the Coal Secretary, after having applied himself to the recommendations of the interministerial committee, comes to a conclusion that there's a prudent case which is made out for a departure from those recommendations, and he sends it.
You're just turning your own argument on its head.
No, I'm not.
It's a different argument to the one you gave me earlier.
I'm not turning the argument on the head. The point that I'm trying to make is that when an administrative head of a ministry, for cogent and prudent reasons, decides to depart from those recommendations and sends it on to the minister, and in this case the Prime Minister, and it is vetted by the Prime Minister's office, obviously the Prime Minister is going to accept it.
Just a moment. If a Coal Secretary is himself overturning an interministerial committee's recommendation without going through a second interministerial committee, then in that particular case, it is incumbent on the Prime Minister to use his judgment and to very closely scrutinize the recommendation before accepting it. And once again, if he did, he's part of the conspiracy. If he didn't, he's negligent.
So therefore, that's why I'm saying that here, if for valid and cogent reasons, because I have not looked at the paper, the Coal Secretary disagreed and he sent that recommendation forth, and it was again vetted by the Prime Minister's office to say that the Prime Minister should then have applied himself to each and every fact in the file and then come to a considered decision disagreeing with what the Coal Secretary has said. I think possibly it goes against the conventions of how governance is carried out at the level of the Prime Minister.
Forgive me. You know the critical implication of what you're saying is that when things come to the Prime Minister for decision making, because they've come from a Coal Secretary, because they've been vetted by the PMO, the PM doesn't need to apply his mind. He can safely and simply rely on the advice he's getting. And that, I put it to you, in a Prime Minister is negligence and irresponsibility.
I think it is neither negligence nor irresponsibility. It is the prudent manner in which governance is carried out. After all, why do you have a bureaucracy?
Pulak Chatterjee should then run the government, not the Prime Minister. Because if the PM is going to sign on Pulak Chatterjee's advice, Pulak Chatterjee is the PM, not the PM.
After all, Karan, then why do you have a bureaucracy? Why do you have different layers of sifting?
To give advice, not supplant the PM's thinking.
So therefore, in this particular instance, when the Coal Secretary disagrees with the recommendations of the Interministerial Committee, for cogent reasons, I presume, sends it to the Prime Minister's office. It is vetted in the Prime Minister's.
For the PM to apply his mind.
It is vetted in the Prime Minister's office, and the conclusions is concurred with. Then to expect that the Prime Minister, because he did not depart, from that particular decision, is complicit in a conspiracy is absolutely totally out of order.
There's a second fact, once again from Friday's Hindu, that contradicts your argument. It was an established rule at that time that in fact when a public sector undertaking has an interest in a coal block, that coal block cannot be allotted to a private entity. That rule was being broken in this instance. It can only be broken if the minister agrees to do so, because the minister has the power to do it. The Coal Secretary doesn't. Given that in this particular instance a rule was being broken to change the allotment and give a share in that allotment to Hindalco, surely the PM would have exercised his judgment, and then in that instance, surely when he did, he'd be part of the so-called conspiracy. He can't allow rules to be broken and say, I simply signed on the advice of my advisors and agreed to what they were saying without exercising my judgment.
Most respectfully, may I put it to you that please go through the C&AG report, which I completely disagree with. The C&AG report points to various instances between 1993 and 2009 where contiguous blocks were awarded to public and private companies. So therefore, if the case that you are making out that this was a one-off departure from an accepted principle, that is completely and absolutely
is not that it was a one-off departure.
And absolutely flies in the face of facts.
I'm not saying it was a one-off departure. I'm saying it was a breach of the rule of the period. And when a rule is being breached, one assumes that
what was the rule, Karan? What was the rule?
I'll tell you.
Now, what was the rule?
It was that when there is a coal block in which a public sector unit has an interest, you do not allot it to a private sector entity.
I'm sorry, that is not the rule.
That is the rule. It's in the Hindu today.
Forget the Hindu. I'll tell you. Forget the Hindu. I'll tell you what the rule is. The rule was that there should be a reasonable distance between a public sector allocation and a private sector allocation, so that the boundaries are seamlessly demarcated.
Forgive me. And that is why. Be the rule.
And please read the C&AG report.
I tell you.
Please read the C&AG report and refer to the Sasan case, where the allocation was made.
You're bringing up different rules to counter a real rule that I'm quoting from Friday's Hindu.
But how do I know that we are quoting a real rule? I am quoting from the C&AG report, which I disagree with completely, where it was pointed out that private and public companies were awarded blocks which were totally contiguous to each other.
Can I point out something, that in fact blocks have been awarded jointly to private and public sector companies, not contiguous blocks, but a point given jointly. If they can be given jointly, surely contiguous blocks will be given as well. And therefore, the rule you're quoting, I'm putting to you, is not a rule at all.
So therefore,
you're simply bringing it up to deflect attention from the rule I threw at.
Karan, essentially this flies in the face of your argument. So therefore, if blocks can be jointly awarded, then why can't blocks be contiguously awarded? So therefore, the argument which you were putting to me earlier, this flies in the face of that argument.
Let's get out of this argument about different rules. Let's take a break, and when I come back, I want to broaden the discussion. We'll be back in a moment's time. Don't go away. Welcome back to Devil's Advocate and an exclusive interview with the Minister of Information and Broadcasting, Manish Tewari. Minister, let's broaden our discussion. Isn't it a paradox that the man that the CAG praised for being the first to suggest that coal allocation should happen by way of auction rather than the select committee method is today accused by the CBI of misusing the select committee method? Isn't that a paradox in the extreme?
Well, you know, since this matter is being monitored by the Supreme Court and it is sub judice, I do not want to go into the substantive aspects of a first information report. But allow me to say, a first information report by its nomenclature is a first information report, and even a charge sheet is the narration of facts and events as best understood by an investigating officer. So it is neither conclusive of innocence and certainly not conclusive of guilt by any stretch of imagination.
You know what your colleagues, senior colleagues in your government are saying in private? They're saying the CBI has gone mad. That is what your own ministers are saying in private. The CBI has gone mad.
Well, Karan, I do not know what my colleagues are saying in private. If they do believe in it so strongly, they should say it publicly. However, I have great respect for the Central Bureau of Investigation for the simple reason that investigation after investigation by constitutional courts have been entrusted to the CBI. The difficulty is that it's a very convenient whipping boy. When there is something which goes in our favor, we praise the CBI. When there's something which goes against somebody, then you call it the Congress Bureau of Investigation or by any other adjective which comes to your mind. So therefore, I don't think it's fair to smear an institution. Yes, if they have wrongly registered an FIR, if their charge sheet turns out to be perverse, it will be assailed in a court of law. They will be deprecated and strictures may be passed. So therefore, allow the process to play itself out.
They have clearly, I suspect, wrongly registered an FIR against Mr. Parekh and Mr. Birla, because in an interview that Ranjit Sinha, the director of the CBI, gave to the Economic Times on Thursday, he clearly said that both gentlemen probably could end up being innocent, that both gentlemen could be exonerated, in which case I ask you, what was the need for an FIR?
Well, I think this question you need to ask Mr. Ranjit Sinha, not I.
Absolutely.
You need to ask Mr. Ranjit Sinha this question. I am neither the administrative minister of the Central Bureau of Investigation. All I'm saying is, as a lawyer, I understand jurisprudence. Jurisprudence holds that you're innocent until proven guilty, and neither an FIR or even a charge sheet is by any stretch of imagination a conclusive proof of guilt.
It's not conclusive proof of guilt, thank God, but in India it is sufficient to damage your reputation. A top industrialist, India's third largest by revenue, one of India's most senior and highly respected civil servants, both have had their reputation and probity and integrity questioned in public by a CBI that today is now saying, 2 days after registering the FIR, that maybe they'll end up innocent, maybe they'll be exonerated. And I put it to you, that was irresponsible of Ranjit Sinha to take the step of registering an FIR if he's not convinced of the case. If he thinks they could be innocent and is saying so in interviews, then he shouldn't have registered the FIR to begin with.
Well, Karan, I am not going to second guess an investigation process and more so less an adjudication process. Let the matter play itself out. If the persons concerned ultimately emerge innocent and their reputations have been wrongly trifled with, there are remedies available in law. And since you bring up this entire case of reputations, I think it's also essential that the media introspects on how it reports some of these matters, because that trifles, reputations far more.
In this instance, however, I can't speak about the media as a a whole, all the facts that I'm quoting to you are absolutely proven.
Oh, absolutely. I am not controverting your facts. I was only on the question of A, what you said is malafide intent, and I added to that reportage, which ultimately has an impact on how your reputation is perceived by people.
Let me end this interview by coming around once again to the simple, truthful point. Only two outcomes are possible. Either there was a conspiracy, as the CBI alleges, and in that event, the conspiracy can't be confined to just Mr. Birla and Mr. Parekh. It would have to logically include the Prime Minister and Dasari Narayan Rao, because A, the file went to them, and without their signing off on it, their recommendation couldn't have come into effect, and B, because the rule was being broken, and therefore all the more reason for them to apply their mind. Or, the CBI is completely wrong. There is no conspiracy, and Hindalco got the allotment perfectly correctly.
Once again, let me deal with both your alternatives. In the first instance, once again, allow me to reiterate the distinction between the administrative head and the political head, one who deals with administrative matters and the other who deals with policy matters. You may not buy it. I'm making that distinction. I leave it to your judgment. Number two, with regard to innocence or guilt, I think let's allow the investigation to play itself out. Maybe after an investigation, they come to the conclusion that there is no case even made out for filing a charge sheet.
And in that event, the CBI will be very embarrassed, and two reputations will have been needlessly damaged.
And in that event, the person who feels that his reputation has been trampled on or trifled with has remedies available in law.
And but that what an unfortunate process! To go through.
That is why, Karan, we need tougher taunts on libel in this country.
I couldn't agree with you, Minister. A pleasure talking to you.